Now, Chief Justice David Maraga has hailed the progress made by the judiciary during his first year in office. He was speaking during the launch of the annual Judiciary Progress Report. Let's listen in.
Kenya envisages that the different agencies of government will continually interrelate and collaborate in various aspects of the administration of justice. During the period under review, there were many collaborative activities under the auspices of the National Council on Administration of Justice. The main ones being the assessment and preparation for the hearing of election petitions, implementation of the bail and the bond policy guidelines, that one, of the Court Users Committee, among others. Through the National Council for Administration of Justice, various stakeholders' interventions were put in place for better administration of justice. Among these were the legislations on children's matters and amendments to the Sexual Offences Act, implementation of the policies on bail and bond, reforms in the traffic sector, and the establishment of the business court users committees to engender investor confidence in our judicial system. A clear evidence of benefits collaboration in the justice sector is demonstrated by the report in the office of the DPP. The ODPP continued deeply to follow the money and the full range of the law approaches, resulting in more cases of economic crimes, abuse of office, money laundering, and organized crime. In that period, there is a total of 3,132 anti-corruption cases registered in the courts, with the ODPP recording an improved overall conviction rate of 72.4% in the financial year 2016-2017, which is the highest ever recorded in Kenya in this type of cases. Along with this was the introduction of alternative dispute resolution mechanisms, key among them being the court-annexed mediation project, in which disputes are settled through mediation by accredited mediators. The successful rollout of this project, Your Excellency, contributed significantly to Kenya's dramatic improvement in the World Bank's ease of doing business rating this year. Our country moved 12 places from position 92 to position 80. We are proud, Your Excellency, to be associated with that leap. Besides the determination through mediation of 93 cases in the commercial division of the High Court, that released close to 1.1 billion that had been tied up in litigation to the economy. The court-annexed mediation continues to resolve many of these cases in the family division. And Your Excellency, we are emphasizing that cases like succession, the heirs, those are not matters that should be heard in court. Mediators can bring the family together and they share out whatever has been left by their deceased parent. Your Excellency, ladies and gentlemen, as I said at the beginning, the presence of all the three arms of government at this event is significant. First, it confirms that Your Excellency fully embraces the doctrine of separation of powers, and that although the three arms of government are independent, they are nonetheless interdependent. When any of them is discharging an important constitutional mandate, they do so in the knowledge that they are constitutional devices created to serve the same people. We do not have separate citizens of this country for the executive, for the judiciary, or legislature. We have citizens of the Republic of Kenya. Secondly, it shows that even though we may not always rule in favor of the government, this does not mean we are enemies. The high-minded doctrine of separation of powers and principles of the rule of law are sometimes necessarily inconvenient, but they need not be a basis for inter-branch friction. The government remains, Your Excellency, a major litigant in our courts, mainly as a defendant, but occasionally as a plaintiff. As far as the judiciary is concerned, the government comes to us just like any other party before court. And so we will continue ruling in favor of the government sometimes, and against it at other times, as guided by the law and the evidence that is placed before us. When the government has a good case, there is no reason whatsoever why we should not rule in its favor. But when the government has a bad case, or it bungles in its prosecution or defense, we should not be expected to rule in its favor.